Welcome back to the Deep Dive. Today we're getting into something that sounds maybe a bit dry, but actually it affects, well, almost everything: statutory interpretation.
It really does. It's where the theory of Parliament making laws crashes into messy reality. Constitutionally, it seems simple. Parliament writes it, judges apply it.
Right, like looking it up.
Exactly. But we're diving into why that simple lookup is often, anything but simple. Judges sometimes have to get very close to making law, not just finding it.
Okay, let's unpack that.
Yeah.
Why is interpretation even needed? Don't they have expert drafters? Shouldn't statutes be, like, crystal clear?
You'd think so. But language itself is tricky, and predicting the future, impossible. So uncertainty creeps in. Three main ways, really.
Right.
First, just simple omissions. Imagine a rule banning men with beards or mustaches from a park.
Uh-huh.
What about a guy with both? Does he get a pass? The drafter probably meant on door, but they just missed it.
So a basic grammar slip-up, not a deep policy issue.
Precisely. Then the second problem, which is maybe more interesting, is broad terms meeting unforeseen events. Think about an old law banning vehicles in a park.
Okay, like cars, horse-drawn carriages, maybe?
Yeah, but what about skateboards? Or, electric scooters? They weren't even invented when the law was written.
Right. How can a court possibly know what Parliament intended for something that didn't exist?
Exactly, and that's where this whole idea of parliamentary intention gets really slippery. It's the goal, supposedly.
What even is it? It can't be what every single MP thought, surely.
Yeah.
Many just vote the party line.
No, definitely not. And it's not just the minister who introduced the bill either. So the court often ends up having to sort of construct an intention, what Parliament would have intended if they'd thought about, say, skateboards.
Which sounds like a huge step for a judge to take.
It's a massive constitutional leap, really.
So given this fuzziness, judges needed some frameworks, tools to help them navigate. You mentioned four main approaches.
That's right. But crucially, the Supreme Court itself said these aren't rigid railway lines, more like guidelines. That was in a case called Cusack v. London Borough of Harrow back in 2013.
So judges have some wiggle room in choosing which approach to use.
They do. It gives them flexibility, which, as we'll see, leads to its own critiques later on.
Okay, let's start with number one, the most traditional, the literal rule.
Yep, the literal rule. It's simple on the face of it. Give words their plain, ordinary dictionary meaning. Full stop. Even if the result seems odd or unfair.
Why do that if it leads to weird results?
It's all about respecting Parliament's supremacy. The thinking is, Parliament wrote these exact words, so we apply these exact words. We don't second-guess them.
But you mentioned weird results. Give us an example where it just looks silly.
Oh, there are plenty. A classic is Whiteley v. Chapel from way back in 1868. The law made it illegal to impersonate any person entitled to vote.
Okay, seems clear enough.
Well, the defendant impersonated someone who had died, and the court said, literally speaking, a dead person isn't entitled to vote.
Seriously, so he got off.
He was acquitted. The literal meaning completely trumped the obvious aim of the law, which was stopping election fraud.
Wow. And isn't there another famous one involving flick knives? Fisher v. Bell?
Ah, yes, 1961. A shopkeeper put a flick knife in his window with a price tag. The law banned selling or offering for sale these knives.
Seems like an offer for sale to me.
Well, the court brought in a technical bit of contract law. They said displaying goods in a window isn't an offer for sale, it's merely an invitation to treat. Basically, an invitation for customers to make an offer.
So technicality wins, defendant walks free, even though everyone knew what the law was trying to do?
Exactly. The literal rule assumes, as one judge put it, unattainable perfection in draftsmanship.
And sometimes it's not just absurd, it's genuinely unjust. That railway worker case, Berriman.
That's a tragic one. London and Northeastern Railway Co. v. Berriman. A worker was killed while oiling the tracks. There was a statute providing compensation, but only for workers killed while relaying or repairing the tracks.
And oiling didn't count.
Under the literal rule, no. Oiling wasn't relaying or repairing, so his widow got nothing. It shows the harshness, the human cost of sticking rigidly to the text.
That just seems wrong. It goes beyond absurdity. So if the literal rule fails that basic justice test, judges needed something else, right? A way to fix obvious problems without just rewriting the law themselves.
Exactly. And that leads us to the golden rule. Think of it as a safety valve.
Okay, how does that work?
It says, stick to the literal meaning unless doing so leads to absurdity or something totally inconsistent with the rest of the law. Only then can the judge tweak the meaning just enough to make it sensible.
So it's like a limited permission slip to avoid the worst outcomes of the literal rule.
Pretty much. The classic example involves bigamy. R.V. Allen, 1872.
Bigamy. How does that fit in?
The law made it a crime to marry someone else if you were already married, but legally, if you're married, you can't legally marry again. The second ceremony is void.
Ah, so literally the crime was impossible to commit.
Exactly. A perfect absurdity. So the court used the golden rule. They interpreted shall marry to mean shall go through a marriage ceremony. Just a small change in wording, but it made the law actually work.
Okay, so the golden rule cleans up grammatical messes and stops really obvious injustices. But what if the problem isn't the grammar, but figuring out what Parliament was trying to achieve based on the history?
Right. For that, we look to the third approach, the mischief rule. This one's much older, dating back to Hayden's case in the 16th century.
Mischief. What does that mean here?
It means the judge has to look back in time. They ask, what was the law before this act was passed? What was the mischief, the problem or defect that the old law didn't fix? What solution did Parliament come up with in this new act? And then the judge has to interpret the act in a way that actually fixes that mischief, that suppresses the problem Parliament wanted to solve.
That sounds much more about purpose than just words, like getting into Parliament's head.
It is. It's more proactive. A great example is Smith v. Hughes from 1960. The Street Offenses Act banned prostitutes soliciting in a street or public place.
Oh.
These women were soliciting from balconies or windows, tapping on the glass to attract men walking below. So literally, they weren't in the street.
Ah, another literal loophole.
Could have been, but the court applied the mischief rule. They said, what was the mischief here? It was people walking down the street being bothered by solicitation.
Right, the impact was felt in the street.
Exactly. So the court said the act did apply because their actions were causing the very problem the law aimed to stop, even if they weren't physically standing on the pavement.
Okay, that makes sense. Now, the fourth approach, the purposive approach, you said it's more modern.
Yeah.
How's it different from the mischief rule?
It's broader, more forward-looking, and I'd say more liberal. The mischief rule looks back at the specific problem Parliament was trying to fix then. The purposive approach looks at the overall purpose or spirit of the legislation now.
So less about the historical problem, more about the ongoing goal.
Yes, and it's really heavily influenced by European legal thinking. It gives judges more leeway to sort of fill in gaps, especially when technology or society has moved on.
And you need that when tech outpaces the law.
Right, absolutely essential. The perfect case is R.V. Quintavel from 2003. It involved the Human Fertilization and Embryology Act of 1990.
Okay.
That act defined an embryo based on fertilization, but then along came cloning technology, creating embryos without fertilization. Literally, the act didn't cover these cloned embryos.
So a massive gap opened up by science.
A huge one. But the House of Lords used the purposive approach. They said, look, the purpose of this act was to regulate the creation of human embryos, whatever the method. Parliament couldn't possibly have intended to live cloned embryos unregulated just because that specific science didn't exist in 1990.
So they stretched the definition to match the purpose.
They looked past the literal words to uphold the act's fundamental goal. It's a very powerful tool.
Okay, so those are the four main internal approaches. But judges also look outside the statute itself, don't they? You mentioned external aids.
Yes, things outside the act itself that can help interpretation. Two really big ones are the Human Rights Act, 1998, and Hansard the record of parliamentary debates.
Let's take the Human Rights Act first. How did that change things?
Fundamentally, Section 3, subsection 1 is the key. It says legislation must be read and given effect in a way that's compatible with the European Convention on Human Rights.
Must be read that way.
So far as it is possible to do so. That's the crucial bit. It's a very strong instruction to the courts.
So if the literal meaning clashes with human rights,
The court has to try and find an alternative meaning that is compatible, even if that meaning seems linguistically strained, as the judges themselves have put it.
wow. That sounds like it forces judges to be quite creative, maybe even ignore Parliament's clear words sometimes.
It can. It pushes towards judicial activism in the name of rights. The case, RVA in 2001, is a prime example. Parliament had passed a law strictly limiting when a defendant in a rape case could bring up the complainant's past sexual history.
Okay, trying to protect victims.
Yes. But the House of Lords said a total ban could violate the defendant's right to a fair trial under Article 6 of the Convention. So they used Section 3 to essentially read exceptions into the Act that Parliament hadn't explicitly put there.
So human rights compatibility basically trumped the specific restrictions Parliament had written?
In that instance, yes. It shows how powerful Section 3 is.
Okay, now Hansard, the official record of what MPs said when debating the law. You'd think judges would always look at that to see what Parliament meant.
Logically, yes. But historically, for over a century, they absolutely refused to. There was a strict rule against looking at Hansard.
Why on earth not? It seemed like the best evidence of intent.
Well, the judges had concerns. Practical ones, like drowning in endless debates, wasting court time, trying to figure out which MP's statement actually mattered. And constitutional ones, a fear of getting dragged into political arguments, undermining judicial independence. Lord Denning, a famous judge, thought the rule was ridiculous.
But that changed eventually.
It did. The big breakthrough was Pepper v. Hart in 1993. It was about how perks given to teachers specifically, reduced fees at the school they worked at, should be taxed.
Right.
The tax office had one interpretation. But during the debate on the Finance Act back in 1976, a government minister had made a very clear statement saying perks that cost the employer very little shouldn't be taxed based on their full value.
And the court finally agreed to look at that statement.
Yes, the House of Lords said, okay, if the words in the act are ambiguous or obscure, and there's a clear statement from the minister promoting the bill that resolves the ambiguity, then we can look at Hansard.
A big shift. But did they throw the doors wide open?
Not at all. They were very cautious. Almost immediately, they started putting limits on it. Cases like Wilson v. Secretary of State in 2003 reinforced these limits.
What kind of limits?
Crucially, you can only use Hansard to understand the meaning of specific ambiguous words in the Act. You can't use it to find out the general policy or the overall reason why Parliament passed the Act.
So only for very specific word clarification, and only if a minister said it clearly.
Pretty much. They wanted to keep the focus on the statutory text itself as the primary expression of Parliament's will, not get lost in the wider political discussion.
Interesting. Okay, one more principle before we get to the big critique, the always speaking idea.
Right. This is just common sense, really. Statutes aren't frozen in time. They have to be interpreted in the context of the world as it is today, not just when they were written.
Like the vehicles in the park example earlier.
Exactly. Or, another old case, Taylor v. Goodwin from 1879. The Highways Act, 1835, banned driving a carriage furiously on a footpath. Someone rode a bicycle furiously.
Bicycles didn't exist in 1835.
Nope. But the court said a bicycle fits the description of a carriage for the purposes of this act today. The law has to adapt. It's always speaking.
Okay, so we've got the four approaches, the external aids like human rights law and Hansard, and this idea that laws adapt. Now, the big question, are these actual rules judges follow, or just justifications they pick and choose?
Well, that's the core of the academic critique. Overwhelmingly, scholars argue they're not rigid rules at all. They're more like tools in a toolbox.
And the judge picks the tool that gets the job done, the job they wrought done.
That's the cynical view, yes. The fact that a judge can choose between the literal rule, which honors the text, and the purposive approach, which honors the spirit, shows there's inherent flexibility, choice.
Is there a specific case that really highlights this judicial flexibility, where the same law got interpreted differently?
The Pinochet case is probably the most stark example. It involved Augusto Pinochet, the former dictator of Chile, and whether he had state immunity from charges of torture.
I remember that.
Yeah.
Huge case.
Huge. And the House of Lords had to interpret the same piece of law, the State Immunity Act, 1978. But because of a potential conflict of interest with one judge in the first hearing, they had to hear it twice.
2 hearings, same law, same facts.
Essentially, yes. In the first hearing, they found he wasn't immune for certain acts. In the second hearing, with a different panel of judges, they interpreted the same act much more narrowly, significantly limiting his liability, mainly to acts committed after the UK implemented the Torture Convention in late 1988.
Wow. So the same words led to different outcomes depending on which judges read them.
It strongly suggests that interpretation isn't just a mechanical process. The judge's own perspectives, the context, the arguments presented, they all play a huge role. It proves flexibility exists.
Which leads straight to that sharper critique. If it's flexible, is it actually political? You mentioned John Willis back in 1938 being skeptical.
Yeah, Willis basically said judges pick the rule that gets the result they think is just. A bit cynical, perhaps.
But then Professor Griffith took it further, arguing it's about policy preference.
J.A.G. Griffith, in 1997, made a much stronger claim. He argued judges often make interpretations based on their own underlying political or economic philosophies. His prime example was the Fairs Fair case.
Right. Bromley London Borough Council v. Greater London Council, 1982. This was a big political battle, wasn't it?
Huge. The Labour-controlled Greater London Council, GLC, wanted to slash tube and bus fares and fund it through local taxes, the rates. This was challenged by conservative-controlled Bromley Council.
And it all came down to one word.
Pretty much. The Transport Act, 1969, said the transport system should be run on economic principles. What did economic mean?
Okay, what were the options?
The GLC argued economic meant cost-effective or efficient in a broad sense, good value for money, considering social benefits like less traffic, less pollution. Bromley argued economic meant run like a business, essentially trying to break even from fares.
Both sound plausible, actually.
They were. Neither interpretation was legally impossible. The judges had a choice.
So what did the highest court, the law lords, decide? And why did Griffith call it political?
They sided with Bromley. They adopted the break-even interpretation, effectively killing the fair policy. Griffith argued this wasn't legally inevitable. He said it reflected the law lord's own strong preference for the principles of the market economy and a dislike of heavy subsidization for social purposes.
So a policy choice dressed up as legal necessity.
That was Griffith's point. He saw it as the unelected judiciary imposing their economic ideology over the policy of a democratically elected local authority, a political act.
That is absolutely fascinating. So we've gone from thinking judges just apply the laws as written to seeing this complex journey from the rigid literal rule, sometimes causing injustice,
Through the safety valve of the golden rule, the historical lens of the mischief rule.
to the much broader purposive approach, heavily influenced by human rights law, giving judges significant leeway. It's clearly not mechanical.
No, it's a balancing act, often involving difficult choices where the law runs out and judicial philosophy, perhaps even policy preference, has to step in. It's where law meets politics and ethics right at the coalface.
It really highlights the boundary between interpreting law and making it. Okay, here's a final thought for you, our listeners, to consider. We talked about Hansard. Since Pepper v. Hart, courts can look at what ministers said Parliament intended.
Right, under those strict conditions we mentioned.
But the courts deliberately limited that. They refused to look at Hansard to understand the general policy or the reasons behind an act, only to clarify specific ambiguous words. So even when Parliament basically tells them, here's why we passed this law, here's our purpose, why do the courts actively restrict how much of that explanation they're prepared to hear?
It does make you wonder about the true dynamic, doesn't it? Who really gets the last word on what the law means?
Something to think about. It definitely shows the rule of law is far more complex and, well, human than it first appears. That's all we have time for on this deep dive. We hope you now have a much clearer picture of how judges tackle ambiguous laws.
And maybe a new appreciation for the battles fought over single words in our statutes.